Welcome to this edition of the Black Law Students Association of Canada's Fireside Chat Series. My name is Leandra Bauman, and I am a second-year law student at the Schulich School of Law at Dalhousie University. Today, I am joined by Natasha Coleman McDonald, Principal Corporate Counsel at Microsoft Corporation, as well as Dr. Brenda McPhail, who is the Director of the Privacy, Technology, and Surveillance Program at the Canadian Civil Liberties Association. They are joining me for discussion around emerging technologies and the law with the specific example of facial recognition technology. Natasha Coleman McDonald is Principal Corporate Counsel supporting Teams calling, meetings, and devices, as well as Teams for Education, Mesh for Teams, and she's also the accessibility lead for Office products in Microsoft's Corporate External and Legal Affairs Department and Experiences and Devices product group. She joined the department in 2018. Prior to coming to Microsoft, Natasha was a litigator, taking on dozens of cases to trial in Superior District and municipal courts in King County. Natasha graduated with honors from Seattle University and Seattle University School of Law and has traveled internationally as an operatic soprano. Our second speaker today, Dr. Brenda McPhail, guides the CCLA's litigation and advocacy at the junction of privacy and emerging technology in her work with the CCLA. Brenda has often served as an expert witness before Parliament, Senate, and legislative committees on legal reforms related to privacy. Her research and public education activities currently concentrate on the social implications of technology, including, most recently, health information sharing, digital surveillance, including facial recognition technology, which of course is a topic we will cover today, as well as AI and human rights and data trusts. So we are honored to have you both with us here today to share your knowledge and your expertise, and I thank you for joining us virtually from your different time zones. Okay, so I thought we could start this conversation from a broader perspective, and I know that you, Natasha, had a slideshow prepared to kind of help give our audience some context.
I do, and thank you for that very warm welcome. I wanted to discuss a little bit about what I do in my role as Principal Corporate Counsel for the Experiences and Devices Product Group. And just to, on the outset, say that although I am licensed to practice in the United States, Washington State, we often do really work with international organizations and regulators on a worldwide scale, just to make sure that we are always kept abreast of all of the emerging technologies and the rules and responsibilities that we have as a provider of services, just to make sure that we are doing everything that is required of us. And so part of that is really making sure that we are partnered with organizations like the CCLA. And so we're very happy to be presenting with Dr. McPhail, and hopefully we will continue to partner more closely as AI and facial recognition continue to evolve in the technology space. Privacy is a large part of my role. Previously, I've supported engineering teams in the Skype and GroupMe teams. Many of you may have heard of Skype and GroupMe. So there are two different categories of data when we're considering privacy. As you may know, we collect very large amounts of data just by being a provider of products and services. So what you'll see here are some privacy obligations that are dependent on whether the data is classified as controller data or processor data. So a controller of data, like a Skype or GroupMe user, for example, will personally determine how their data will be handled. So if you have a Skype account, you can determine when your data will be deleted, if you want to completely delete your profile, if you would like to move your data altogether, which is called data export, or just any kind of consideration that you may want to give to your data, you make that personal determination. On the other hand, if we're working with a large corporation or business, which is considered for us an enterprise customer, it is considered processor related data. We only handle that data as that business or corporation specifically designates. So it's the whole of that corporation that we're considering, and we are using that data at the request and the behest of the school. So these two designations are important to determine the way in which data is handled, and there are different regulations depending on whether or not we're providing services in Europe or Asia that will specify how we should handle that data accordingly. Another piece of information for you in terms of what I deal with is Teams for Education, or Teams EDUs is the shorthand way of saying it. Two laws that are fundamental to that role are COPPA, which is the Children's Online Privacy Protection Act, and FERPA, which is the Family Educational Rights and Privacy Act. COPPA protects a child's privacy when that child or student is online, and FERPA protects a student's educational records in a school setting. Those are the laws that determine the way in which student data is handled. And because we consider school districts to be enterprise customers, we will use that data and handle that data at the request of the school or as the school designates. So during the pandemic, there have been a number of schools that have had safety concerns with the use of chat in the classroom. We assist schools with creating a safe environment by providing tools that enable them to do things like delete the chat if it's inappropriate, safeguards that determine who can join meetings in case a teacher may not recognize someone who has joined. We also provide references to third-party tools that allow teachers and educators to moderate their chat. But at all times, we handle customer data, again, as requested by that school district. There are, as I mentioned previously, third-party content moderation tools that schools use to determine whether or not those students are safe, which are very, very important, I would imagine, in the Canadian context as well. And those tools determine whether bad words are used or any offensive language is on the platform, whether students might be bullying each other, whether they might be conversations about drug use or suicidal ideation. So we constantly balance this concern about student privacy, making sure that students are able to have data on a platform in a way that respects and honors their requests, at the same time with making sure that it's a safe platform for all students. I'm also the accessibility lead for Office products, which means that I ensure that our teams are creative, inclusive products. And Microsoft is committed as a whole to developing products and services with inclusive design in mind, which takes into account the global accessibility standards, such as the 4 laws that you see listed here. Testing is performed against those standards, and we provide transparency as to how those standards are supported through published accessibility conformance reports. They are the Communications and Video Accessibility Act, the European Norm 301549, the federal standard, which is the US Section 508, and the Web Content Accessibility Guidelines. So now that I've discussed a little bit about myself, I'm going to hand it off to Dr. McPhail, who's going to describe a little bit about herself as well.
Thank you. I'll keep it very short because we've got so many interesting topics to cover. And honestly, my bio described a great deal of what I did or what I do for CCLA. CCLA is an advocacy and human rights civil liberties organization that's been active in Canada since 1964. So we have more than 50 years of history in engaging in legal advocacy in the public interest. What that means is that we either serve as an applicant ourselves or we intervene in the public interest in cases at all levels of court, from first instance through to the Supreme Court of Canada. And in fact, we are the civil society organization in Canada who has appeared before the Supreme Court more than any other. My role at CCLA is an interesting one in that I am the only program advocacy director who is not a lawyer. I did my PhD in essentially social implications of technology at the University of Toronto. And my thesis work was around workplace surveillance, which is where I became very engaged in the human impacts of surveillance and the necessity of privacy as a way to protect human dignity. So that's the work that I do, both in the courts by taking forward litigation that attempts to help the court see that the principles that are important, that are protected in our charter, apply regardless of the affordances of any particular technology, because we increasingly see new technologies that facilitate ever more granular, detailed knowledge about people through different kinds of surveillance. But in a democracy, it's not just what we can do with technology, it's what we should do that counts. So that's my focus in a nutshell for the Canadian Civil Liberties Association.
Thank you both. I mean, I think there are definitely people who are probably interested in the work that both of you do. So I think that's definitely insightful to hear about kind of your day to day. So Natasha kind of laid the foundation of sort of on a more global scale, but also in the American context for privacy law and the work that she does. I was wondering if you, Brenda, could maybe take us through how you see privacy law in Canada, just to give our audience that context.
Well, most of my practice really has been focused on privacy law, obviously, in the United States. But what we're noticing globally is that with things like the General Data Protection Regulation, which is a very significant piece of European legislation, which requires that worldwide technology products and services are significantly more thoughtful about the ways in which they handle personal data. So you may or may not have studied this in your specific school, but what the GDPR is the shorthand way of, or the acronym for the General Data Protection Regulation. What it stands for is the proposition that privacy rights really should be held inviolate. Now, the interesting piece to that is that although in the United States we value privacy greatly, as I'm sure Canada does as well, there has to be a balance to how privacy is treated. So, for example, if there are offensive words in a chat that may be used, or predatory language that an adult may be using towards a minor, then in that case, questions need to be asked about whether or not we should be holding privacy at a greater standard or a greater level than things like digital safety or online safety, because the threats to minors online is very real. So we are constantly trying to achieve that balance. And I would imagine that Canada would have some similar concerns as well. And I'm very happy to see the work that the CCLA has been doing around facial recognition, because I do think that the CCLA does share a very common perspective with Microsoft, in that it is not just a concern about privacy and just sort of moving through the artificial intelligence technologies and not really asking ourselves those hard questions about, are these tools like facial recognition technology, or FRT is the shorthand way of saying it as it's referred to commonly, is FRT really safe, and is it treating all citizens in the exact same way? And if the answer to that is no, or not right now, then do we have a set of systems in place, and can we work together with partners like CCLA to make sure that we are thinking about and listening to some of the bigger issues that facial recognition, like some of the inequities that are existing? What kind of data are we looking at? Are we dealing with data sets? Are we testing, and through our machine learning process, are we using tests in our machine learning models that enable us to have a comprehensive data set that looks at all kinds of skin tones, all kinds of complexions and hair types? Or are we just looking at one kind of data set? So these are questions that we're really happy to be partnering with CCLA on, and it's specifically because we're really happy to see the progressive ways in which they're viewing this technology and the thoughtfulness that they're putting into making sure that it's equitable.
Yeah, interesting. Yeah, I wonder if you could elaborate, Brenda, as well on that topic.
So Natasha was speaking about the GDPR, which is the European regulation. It's often viewed as a gold standard. I regret to share with you that the current state of privacy law in Canada is not quite up to that standard. In fact, privacy law in Canada is both complex and out of date, which as law students you'll understand is not a good combination. So very briefly, because it's going to help with understanding the issues that we're going to discuss in the rest of this talk, I'm going to give you the 3 or 4 minute bird's eye view of Canadian privacy law. And I'm going to start big. So our recognition of privacy as a human right is grounded in the international treaties that we've ratified, the same treaties that form the foundation of the GDPR's focus on privacy as a human right. Those include the UN Convention on the Rights of a Child and the Universal Declaration of Human Rights, which in Article 12 says no one shall be subjected to arbitrary interference with their privacy, family, home, or correspondence, nor attacks upon their honor or reputation. And it's this understanding that's also supported in our Charter of Rights and Freedoms here in Canada. Although as law students, if you've taken constitutional law, you probably know that the word privacy doesn't actually appear in our charter. That means that it's been read into different sections by our Supreme Court, which makes it technically a quasi-constitutional right. The 2 sections of the Charter that have been deemed to support privacy interests and protect privacy interests in Canada are Section 7, which protects our rights to life, liberty, and security of the person, and Section 8, which protects against unreasonable search and seizure. So that's the supreme law of the land in which privacy is protected. Then we have both public and private sector specific privacy pieces of legislation. Lots of them. So for the first, federally, for the public sector, we have an act called the Privacy Act. It was first passed in 1985, and it governs the way that federal institutions, including the RCMP, because you're going to see I'm going to have a policing theme as I go through my comments, collect, use, and disclose personal information. And then we have something called, and it's a mouthful, the Personal Information Protection and Electronic Documents Act, which I will subsequently refer to as PIPEDA. And that applies to private sector organizations who collect, use, or disclose personal information during commercial activities. Then it gets more complicated. PIPEDA is a federal law, so it governs some activities around commerce that would otherwise normally fall into provincial jurisdiction. So part of the compromise when that law was passed is that it was allowed that provinces who wanted to enact their own substantially similar legislation instead could do so. So we have 3 provinces who did that, Alberta, BC, and Quebec. So they each have their own private sector acts that are deemed substantially similar to PIPEDA but have interesting wrinkles. And what that means from a due process and justice point of view is that some provinces have different privacy protections than others, including, and this is important again for what we're going to talk about later, more powers in those provinces for the privacy commissioners to issue binding orders or levy fines. Then there are municipal acts in some places which cover municipal bodies, including often city police services. And then finally, there are provincial privacy health statutes. In total, there are more than 40 different privacy laws in effect across Canada, making it a very challenging environment for lawyers, for law students, for corporations, for anyone who genuinely wants to comply with the law and take protecting privacy seriously. And the kicker, of course, is that almost all of them were put in place where the word file meant a bunch of papers in a cardboard folder. And high-tech surveillance was wiretaps. Okay, so we're very lucky. The reason that these laws have survived and are even moderately effective at this point is that they're largely technology neutral and they're principles based, which means that despite their age, they often do apply to the ever-increasing incursions on privacy that are caused by data-driven technologies. But it's also becoming increasingly obvious that there are gaps that have emerged when we consider a technology like facial recognition, which we're going to go on now to do.
Yes, well, you both touched now on facial recognition technology and on a lot of the points that that I was thinking of bringing up later in this discussion. And since you have the slide up, Natasha, I was wondering if now that we have the basis of privacy law, both in American, Canadian, and even global contexts, I was wondering if we could, narrowing it down, talk about FRT and just generally how it's being used today before we look at the legal aspects.
Sure. First, I'll talk about facial recognition, the definition, what it is, and then give some examples of how it's currently used.
Perfect.
So let's start by looking at what the technology does. There are a number of different functions that FRT models perform. We'll start with facial detection. This is a form of object recognition where the model is answering the simple question, is there a face contained in this image? If so, where is that face or image located? It's the kind of function that's on your camera to help it optimize autofocus on the faces in a picture that it's taking. All other facial recognition functions are based on this kind of detection. Another task is facial verification. This is where the system answers the question, are these images, two images that are similar, the same person? It's a one-to-one matching system because it's asking what is known as the probe image or the image that has been submitted to the FRT system and matches it to an image of a person that is stored in a database. To do this, a system analyzes the characteristics of the two images and generates a match score between 0 and 1 based on how closely the features in the two images match. This function is often used for security purposes to make sure that a person is who they claim to be. Like, for example, when you're logging into an iPhone or you're getting into one of your Windows devices and facial recognition is used. So it's important to set the right match threshold for your scenario. For logging into a device, you would want a high threshold so that it's only letting you unlock your device, but not so high that if you've grown your hair out or the room is slightly darker or you're wearing glasses, that your device becomes inaccessible to you. Then there's facial identification. That's where a system seeks to answer the question, can this image of an unknown person be matched to an image in a database? Again, the system develops a match score, and based on a user's match threshold, a list of candidate matches is generated for a human to review. This is being used in some technology being developed for people with low vision, and it will help to flag someone that, for example, your friend Sarah is in the corner of the lunchroom, or by law enforcement to generate leads for further investigation. How are these technologies used currently and in a responsible way? It's currently being used by groups to address things like sex trafficking and find missing children. Thorn is an organization founded in 2012 by Demi Moore and Ashton Kutcher to defend children from sexual abuse. Spotlight is a facial recognition tool that has correctly identified 18,000 victims of trafficking in the last 4 years in the US and Canada, including 6,000 children. Each day, law enforcement agencies use Spotlight to identify an average of 9 children. In a trial in India, Delhi police were able to reunite 3,000 missing children with their parents in just 4 days using a facial recognition tool. So we can clearly see the benefit to using facial recognition. It's also happening with people with low vision better navigate the world with technologies like Seeing AI and Project Tokyo, using facial recognition to help people with low vision engage more effectively during conversations and meetings by helping them direct their gaze to people's faces and helping them identify friends and colleagues, which will allow them to in turn engage more effectively at work and socially. There are also some rudimentary uses to improve convenience, like contactless check-in. Department of Motor Vehicles is using facial recognition to stop driver's license fraud. And in New York State alone, the DMV has identified more than 14,500 people with 2 or more licenses, which are all fraudulent. Interestingly, research demonstrates that the combination of using human facial recognition delivers better performance than either a human alone or facial recognition alone. The abilities are complementary, with FRT being able to quickly search enormous databases that would take a human months to do, and serves up a potential short list of matches that a human can then focus in on. The National Academy of Sciences found that human plus FRT review was 35% more effective than just a human or just facial recognition alone, and that the effect of that is true with both professionally trained face examiners and non-trained people as well. I'll stop here before we start talking about some of the regulatory issues.
That's perfect. Well, that definitely lays a good foundation for people who aren't familiar with the technology. Was there anything that you wanted to add, Brenda, on that point?
Absolutely, and I'm very grateful for Natasha for taking on the task of laying out some of the socially beneficial uses, because of course, as a civil society advocate and as a working in a legal reform organization, the examples that attract my attention are usually the bad examples, which I do think are particularly helpful in allowing us to think through where our laws are falling short. So I'm just going to add to what Natasha has laid out by calling your attention to 2 particular uses in Canada that attracted legal attention that I think law students will be particularly interested in, one in the private sector and one in the public sector. The private sector one involved 12 Cadillac Fairview shopping malls. Cadillac Fairview decided it would be helpful to run facial analytics. So facial analytics are sort of like the step before recognition, where they use your face to figure out demographic characteristics, like potentially race or age or gender, but then they stop short of trying to match those characteristics with a name. So they decided that they would use facial analytics on their customers. But they did so surreptitiously, using little cameras that were embedded in the information kiosks in their malls. And this was only discovered when one of the kiosks malfunctioned, so that the code displayed and someone who recognized what it was saw it and complained to the Privacy Commissioner of Canada. That investigation under PIPEDA, because it's a private sector issue, found that 5 million people's faces were scanned during the use of that technology in the malls, and data was stored that included sensitive biometrics without any meaningful consent. What did the company do in response to that investigation? They did stop using it. They also dispute the findings, and they haven't promised not to use it. They only promised not to use it in the future without paying attention to consent laws in Canada. They didn't promise that they would include opt-in consent, which was the recommendation of the OPC. And the OPC, the Office of the Privacy Commissioner of Canada, can issue recommendations, but not binding orders or administrative penalties. So the result of that investigation was a series of recommendations that may or may not be complied with in the future. The public sector case is the case of Clearview AI. If this was a live talk at this point, I'd ask for you to put your hands up if you've ever heard of that organization, because they've been in the news in the US, in Canada, and in Europe regularly over the last couple of years. They're an American company that created a facial recognition tool where they developed their face database by scraping more than 3 billion images of people off the internet, often in defiance of the terms of service of the sites where they extracted the photos, and completely without the consent of people who posted who were in the photos. And in Canada, one of the wrinkles of our private sector privacy law is that information that's shared publicly for a particular purpose is not necessarily fair game for any other secondary use by any other party, particularly when those photos are posted on a site where there are terms of service that the individual could expect to be followed. But regardless, Clearview scraped the photos and marketed their database and the AI facial recognition tool that went with it to police forces around the world, including to forces across Canada. And this is where it gets even more fun, because the standard in marketing approach by Clearview was to hand out essentially free samples of their product to officers who were attending trade fairs or conferences. Tell them to take it home, try it out, see how it went. More than 30 forces across Canada, to the best of our knowledge, including the RCMP, had divisions that experimented with the technology after receiving one of those samples. In every case, apparently, without subjecting it to appropriate privacy or legal assessment. And in many other cases, by their own admission, apparently not clearing it through a regular procurement process that would involve people up the command chain understanding that this technology was being experimented with and possibly encouraging a consideration of legal compliance. This all came out not because police forces decided that they should be transparent and accountable about their use of this tool, but because in January 2020, a New York Times reporter named Kashmir Hill published an investigative piece about the company that included links to the company website, where there was front and center a quote from a Canadian constable about how awesome the product was. Canadian media organizations like CCLA pounced on this, started asking Canadian forces if they used it. I filed dozens of access requests, to which I got, we will neither confirm nor deny. Media were a little bit more successful. They got eventually a mea culpa, where a number of forces who initially said we're not using it came out and said, whoops, actually, you know, some officers were using it, sorry. So we've already discussed how Canada's privacy regime is out of date, but the fun part of the Clearview story is that the vendor is covered by PIPEDA, the Private Sector Act, and police forces are covered under a range of mostly provincial municipal acts, although the RCMP, the federal police body, is covered under the Federal Privacy Act. So sorting through who broke what law when, or if they did, as law students, you'll understand is, you know, both fascinating and thorny. And again, there were investigations by a joint commission of privacy commissioners to try and get the rules in all of the laws brought to bear in that incidence, which eventually issued a really scathing judgment that it's well worth your time to read, where they said that that particular tool essentially constituted non-consensual mass surveillance. It's one of the most direct, pointed investigative reports that has ever come out of a federal or a provincial privacy commissioner's office on that topic. Mm-hmm. And the last wrap up to that is provinces who have the capacity to do so issued binding orders telling Clearview AI to take Canadian images out of their database. Okay. Clearview says that's not a reasonable request, and they maybe don't have to do it because it's Canadian law. And they're going to court in all of the various jurisdictions, Alberta, Quebec, BC, and federally, to fight those orders. So this is something for law students to watch, because it's going to be a very hot piece of litigation.
Yeah, it's definitely shows the messiness sometimes of federalism in Canada. So, I mean, thank you, Brenda and Natasha, for pointing to kind of a more balanced picture of how FRT can be used, perhaps misused in certain instances. So we just talked about sort of public regulations, but I was wondering if you, Natasha, could tell us what role industry might be able to play in promoting more responsible use by developing guidelines, their own guidelines.
Yes, I'd be happy to. So we'll talk a little bit about some of the big issues that we think should be addressed by regulation. So whenever we build out our internal processes, we have taken a decision to do more by using our voice to advocate for the creation of new laws that will ensure responsible use of facial recognition. What you're looking at is a December 6th, 2018 blog from Brad Smith, who's president of Microsoft and head of the legal department, calling for action on the regulatory front. Now, while we're very aware that specific AI-focused regulation on facial recognition is still developing in Canada, as I said, we're looking forward to working with international organizations and specific organizations like the CCLA to develop a framework that will be used in advocating for legislation with a responsible AI focus. For Washington State specifically, as we discussed earlier, it's developing rapidly around facial recognition, and Microsoft is supportive of those changing landscapes that are happening now. And it's great to see the way in which Washington has really started to lead the world in developing a strong law or set of laws that allow for the responsible use of facial recognition while ensuring that safeguards are in place so that we can use facial recognition responsibly. It focused on government use and has some important elements. The first, and this should be used in any legislation, is transparency and independent testing. Any agency wanting to use facial recognition must publish an accountability report setting out how the technology will be used and the processes and training by which they have developed internally to ensure that it will be used in a responsible way. Critically, no decision can be taken by facial recognition itself. Human oversight and review is required by law. The law also includes civil liberty protections to ensure that facial recognition cannot be used for mass surveillance or persistent tracking, except in very exceptional circumstances and where there is a warrant that's in place that can be executed. FRT can't be used on the basis of a person's religious, political views or any activities that they've been undertaking, and it cannot be used for purposes of probable cause. Now, in the American system of criminal justice, that means that a police officer can pull you over only if they have a reason to do so, to suspect that you might be breaking the law. Facial recognition cannot be used for that purpose. We have also been pleased to see that there has been action with the European Union. There's an EU AI Act, and these international jurisdictions mean that the use of facial recognition is very high risk, and it's been identified as such internationally now. They're looking at facial recognition and other biometric ways of identifying people. This would include, for example, the tone of someone's voice or their gait, just simply the way they walk. There are also provisions for independent testing. Law enforcement may only use facial recognition with the investigation of serious crimes. Now, this currently is just in the EU, and we'll see if that will expand to countries like Canada and the US as well. These are important conversations to demonstrate that regulation is possible. Illinois also had a very monumental law around the use of biometric technology, and we often will use that Illinois law in the United States as a guide for how we will continuously develop a national set of regulations that will be very similar to the way in which Illinois has crafted their legislation. So those are just some of the ways in which we've been trying to consider how we can most comprehensively craft legislation that addresses all of these principles.
Yeah.
The other piece and the final piece is how we build trust and use facial recognition responsibly. And I think you were going to ask another question there, so I'll let you go ahead, Leandra, and ask your question.
Yeah, well, I mean, you kind of preempted where I was sort of going. I mean, you touched on this before, and Brenda certainly touched on this, but, you know, a lot of the discussions that have arisen, especially after the New York Times piece, have kind of focused in on some of the risks for facial recognition technology. And so I just wanted to highlight, for further context, sort of what the particular concerns around FRT might be when it comes to its use and its civil liberties implications, and also its implications for racialized communities in particular. Perhaps you want to start on this, Brenda?
Sure. I mean, Natasha talked about the principles that we need to consider if we're going to regulate this technology. I'm going to explain the reason why it's absolutely imperative that we consider them. And we need to do that, we need to start with an understanding of the nature of technology. It is a myth that technology can be neutral. It's a human creation, which means from conception to design to implementation to subsequent audit or monitoring, it has the potential to be influenced by human bias, whether consciously or probably more often unconsciously. And it's also always affected by the very human goals that are the impetus for its development. And in other words, the reasons for creating a piece of technology influence how it's ultimately going to be designed to work. And then it gets marketed and sold to customers who have their own reasons for using it within their own socio-technical systems. In systems where they have their own goals, their own needs, their own stakeholders, their own policies and procedures. So with a technology like facial recognition technology, we need to think about who's making it for what, who's buying it for what, because there are actors creating their tools using the kind of principled process that Natasha just described, and there are those who aren't. And there are users who have goals that may or may not be socially beneficial, or may feed the embedded biases of a system if you really subject those uses to an appropriate level of scrutiny. So as a civil society organization, CCLA is especially interested in the relationship between state actors like police and the public when it comes to using this kind of technology. And I think policing is a great area to use to highlight some of the civil liberties concerns that come from introducing a powerful technology into an existing system that has a legacy of successes, but also failures. So first, if facial recognition technology is used in the wild, that is, on our streets by police, in a form of sort of general surveillance in case they're able to see someone who's doing something wrong, that has the potential to remove our ability to move unidentified anonymously through public or quasi-public space. Why does that matter if it's about catching bad guys? It's a fundamental tenet of democracy that people have a right to go about their business unmonitored by the state, absent a compelling reason, such as a reasonable belief that they have or are imminently about to commit a criminal act. So if we have a technology that renders us easily and ubiquitously identifiable, that has the potential, unregulated, to fundamentally change the nature of citizen-state relationships. That matters. Along with that, our Charter of Rights and Freedoms protect freedom of association, including for purposes of dissent. And all of us here in Canada understand the nature of dissent at this particular juncture. We have protections for freedom of expression, for being free of unreasonable search, around the presumption of innocence. All of those rights are impacted in situations where we are or might be ubiquitously watched. It's particularly the case, and there's research to support this, that people may be less willing to take a political stand and engage in actions of protest or dissent when they fear surveillance. Lastly, there's the issue of discrimination, and it has two sides. First, there are many studies that demonstrate that some facial recognition technologies are more accurate on adult male white faces and less accurate on faces that are Black, Indigenous, brown, Asian, female, young, essentially anything other than white and male and middle-aged. What does that mean? Again, just sticking to the context of policing, it means that non-white accused persons are more likely to be misidentified. There's a case that the American Civil Liberties Union is working on right now, where a Black man was arrested in his home and dragged out in handcuffs in front of his very small children based on that kind of misidentification. That's an example of the human impact that kind of misidentification can have. The other side of the issue is that, of course, an imperfect technology can get better. We can develop technologies that do recognize all colors and shapes and kinds of faces. What does that mean in the context of discrimination and racial justice? It means that the technology will be even more useful to surveil those populations that, as a civil society organization, we already know are over-policed and overrepresented in charges, in bail denials, and in our prisons, which again in Canada particularly includes people who are Black and Indigenous. So in other words, FRT is a tool that carries the potential to exacerbate systemic injustices in long-standing relationships between groups that have power, like police, and those who don't in our justice system. And that's why, absent a rigorous legal framework and serious systemic reforms, we have grave concerns about the introduction of these technologies into these contexts. And it makes the concept of legal reform absolutely urgent and imperative.
Okay. Oh, just elaborating on that, from your perspective, Natasha, are there any kind of concerns that you have within your organization that you're seeking to address? I know you kind of touched on that earlier, but would you like to elaborate?
Yes, so the first thing that we would like to do is establish a sense of trust such that people are able to trust that the facial recognition technology that we are using takes into account all of the issues that Dr. McPhail just outlined, and then have an inclusive, evidence-based conversation that says we are ensuring that a broad range of voices and communities are heard and are being used for testing. At the end of the day, these technologies are used by engineers in a machine learning environment and they are tested. There are data sets at the very inception of the development of these technologies that are being used. So the question is, where are we obtaining the data? Is the data being obtained from a place that is inclusive of all shapes, of all faces, of all different kinds of people? Is there a diverse data set? Are we ensuring that all technology companies that utilize and develop this kind of technology have systems in place to ensure that at the inception phase of design and development, that we're doing so in a responsible way and that our engineers are testing from a diverse data set? And finally, are we creating regulations for the responsible use of data? How are we being advocates in the legislative context to ensure that what we know about the irresponsible use of facial recognition technology will be stopped by some of these rules and regulations and laws that will be put in place? And so another emerging part of the debate is the way in which human beings and facial recognition together might be able to address some of the inequities. And we touched on this a little bit earlier. And this is within certain systems that rely on identification, including the criminal justice system. A 2015 Seattle University Law Review paper showed that about 75% of 5,000 to 10,000 wrongful felony convictions in the United States each year involve eyewitness misidentification. And based on this conversation, you may have already guessed it, for all the law students there, approximately 42% of these misidentifications are cross-racial misidentification. And around 1/3 of those wrongful convictions uncovered by DNA analysis involve a white person that is misidentified, a Black person. So some of the lessons that we've learned from these deliberations have informed the development of Microsoft's artificial intelligence program. This has been the case in relation to facial recognition, where our concerns around the premature use of FRT lead us to think more deeply on how we can guide the development of technology internally. With the creation of these specific principles that are outlined here, these 6 specific principles are building and adding important considerations around ensuring that there's non-discrimination at the design stage of development, that there's notice and consent and lawful surveillance. It also has led us to develop our transparency in the process, which documents that we provide to customers to help them understand the capabilities and also some of the limitations of the systems that we have in place, and that they will need to think about their own deployment environments rather than just relying on an imperfect system. So in Microsoft, our responsible AI journey began nearly 3 years ago. with Satya, who's the CEO of Microsoft, Satya Nadella, penned an article in Slate magazine entitled "The Partnership of the Future." This article introduced concepts of transparency, efficiency, however, not at the expense of the dignity of people, intelligent privacy, algorithmic accountability, protection against bias, and this has informed the creation of the company's responsible AI principles. A big part of the work that we've been doing has been focused on FRT as an important technology to develop responsibly. And this starts with Microsoft's calls for facial recognition regulation, and this is back in July of 2018. The principles for facial recognition were published in December of 2018, and then finally, in 2019, Microsoft formed the Office of Responsible AI, which is an entire department of analysts that are brought together to discuss all of the principles that we have been discussing today across all of the products and services that Microsoft has to offer. So it is a specific part of the company that is flagged for whenever there is biometric data that's being used, whenever there are AI concepts in products and services that we're going to be putting out to market, that is flagged as a review that has to be done by the Office of Responsible AI to make sure that we are including all of these principles in the technology that we are bringing out into the market today.
Yeah, it's so interesting and insightful to have that kind of both of your perspectives here today from like a public point of view and more from an industry point of view. So in that vein, just to wrap up as I'm mindful of both of your time, do you think that this area requires a bit of legal innovation in the sense that maybe specialized frameworks should be developed to regulate FRT? And do you think it requires more integration of industry within, like in promoting responsible use? So that's a question for both of you. Maybe Brenda, you can start off.
So absolutely, now is the time for some innovative thinking when it comes to how we as a society take stock of first, if there are uses of this technology that are socially beneficial and useful in a democracy, and then once we've established what those uses are, how they can best be regulated. One interesting model actually would draw on some of the great work that Microsoft has done internally, in that CCLA has put forward the idea, in part following the lead of a couple of law professors here in Canada, Professor Lisa Austin and Professor Andrea Slane, that what we need to consider is we need to be creative and create an independent external oversight body that would engage in the kind of detailed, granular, ethical conversations that Natasha's been describing in terms of Microsoft's internal processes, but at a larger level, at a social level, at a societal level. And engage, so essentially engage in an independent review of these new investigative technologies, new surveillance technologies nationally, develop guidelines for their use after extensive consultation with stakeholders that range from industry to civil society to the public, with particular attention to those groups who have lived experience of being on the wrong end of this kind of tool, who have experience with the kinds of ways in which the best intentions for a tool for a noble sounding purpose can backfire in an environment where systemic discrimination is so embedded in a system that we don't properly recognize the risks that entails when you add the technology into that mix. So we advocate for that kind of body that would develop guidelines for use, would establish protocols for authorization for the technology, and really transparent accountability requirements around monitoring and auditing the use of the technology across, socially consequential applications or implementations.
Is there anything that you would add to that from your perspective, Natasha?
Yeah, so just to talk a little bit about what the Office of Responsible AI does. It's a part of our governance infrastructure, and it involves our Ether committee of senior AI researchers and engineers. Our RAISE team, which works with the engineering teams to implement our responsible AI principles into their work every day. And ORA, the Office of Responsible AI, creates internal rules for how our colleagues implement all of our principles. This has to be consistent with our company's external policy work as well, which includes things like making sure that we're working very closely with organizations like the CCLA that understand some of the inherent biases that the technology can introduce and is committed to resolving them. We also have AI champions or champs embedded within the engineering and sales teams worldwide to help them implement our principles and identify responsible AI issues that need to be addressed. And I think it's worth noting that, and perhaps this is the case in Canada as well as the United States, there has been lots of talk about what it means to be diverse and what it means to be inclusive. And it's not just attending a seminar or making a donation to your favorite charity. It's also making sure that every day in the development of our technologies, that we are being thoughtful about the ways in which our technology can impact people for the better and for the worse, and that we're taking the lessons learned from the experiences that have happened to people, the real life tangible examples that have really ripped apart the fabric of people's lives. And we're really taking into account what we do from this point forward to ensure that it never happens again. And so that's the reason why the Office of Responsible AI is working so closely with some of these really fantastic external organizations like the CCLA to make sure that we are making progress and that our technology is as inclusive as it possibly can be.
Well, I think that's a good note to end this discussion on today. I just wanted to thank you both again for joining us with these insights and with your expertise, which I'm sure that all students will benefit from, whether they're interested in doing the specific work that you do or whether they're just, interested as citizens in the world. So thank you again, and enjoy the rest of your days.
All right. Thank you.
Thank you so much for the conversation. It was a real pleasure and a privilege to be here with both of you.
Yes, for me too.
Thank you so much for having us.